Good morning, everybody. My name is Eric Machum. I'm a lawyer at Metcalf and Company in Halifax, Nova Scotia. We're a boutique law firm that deals a lot with marine, transportation, and insurance matters. We do other commercial work as well. But before that, I was a lawyer in Clyde & Co. in Caracas, Venezuela. And in between all those various law jobs, I actually went to law school, including at Dalhousie University, where I must have distinguished myself enough with Aldo and Meinhard and David that they've invited me to contribute a piece to their MELAW's 40th anniversary conference. So congratulations, guys. You've been around longer than I've been born, doing many great things at MELAW, and I'm sure there are many, many other great things still to come. All the best. Now, on to the main event, my presentation on what's in a name and the personification theory of ships. The origin, or what triggered the idea to make this presentation, was a recent decision issued in October 2014 by the Federal Court of Appeal in Canada in connection with a ship called the Cape Apricot. That decision confirmed that in Canada, ship arrests cannot be stacked, and that security can only be obtained up to the value of the vessel actually arrested. This indirectly raises the question of the legal personality of ships. So at law, ships, like corporations, have been given names and held to be persons. At least that's what we're going to look at, whether they are actually persons. And as such, as persons, they'd be subject of rights and duties. Now, traditionally, personification grounded or explained the maritime action in rem. That is, a legal action against a ship or other property such as cargo or freight, but most significantly, not against its owner. The action in rem may be commenced if the claim is supported by a maritime lien, which is a very special right that follows a ship irrespective of the owner's personal liability. A maritime lien arises in connection with specific creditors and specific circumstances, and then it includes claims, for example, like a crew's claim for wages and other remuneration, claims in respect of loss of life or personal injury in direct connection with the operation of the ship, claims for reward for the salvage of the vessel, etc. More recently, the personification theory has been challenged by those who suggest that it is only a procedural fiction designed to flush out the underlying ship owner. So this presentation will, in I hope under 20 minutes, examine the philosophical merit of personification and the procedural theories and their legal effect, and then whether personification is still justified today. So first, I'll review each theory, personification and procedural theory, and then consider them in light of the positivist and natural law schools of thought, and then go into the question of, is it still justified? Well, personification theory holds that the ship itself is the wrongdoer and the defendant in an action in rem. Its high point was the 1902 U.S. Supreme Court decision in a case called Tucker and Alexandrov. In that case, and I quote, the court held that prior to her launching, she is a mere congeries of wood and iron, an ordinary piece of personal property. In the baptism of launching, she receives her name, and from the moment her keel touches the water, she is transformed and becomes a subject of admiralty jurisdiction. She acquires a personality of her own, becomes competent to contract, and is individually liable for her obligations, upon which she may sue in the name of her owner and be sued in her name. Clearly, the courts were much more prone to literary flourishes at the time. It's a nice little passage. So, under this theory, the effect of commencing an action in rem is to create or give effect to what are, in fact, substantive rights over the ship that can be enforced without the need for any concurrent personal liability on the part of the ship owner. So, the ship is deemed to have legal personality because it is both the source and the limit of liability. The precise origin of that theory is not clear. One hypothesis is that it was introduced in the early U.S. forfeiture and piracy seizure cases. So according to Gilmore and Black, and again I quote, the fiction of ship's personality was introduced as a literary flourish in forfeiture cases. It served as a convenient reason to explain why ships should occasionally be liable to arrest, even though the underlying claims could not be enforced against the owner. An alternate hypothesis is that the fiction arose as a result of the jurisdictional assault of the common law courts on the Admiralty courts in England, in response to which Admiralty lawyers and judges got creative and used the concept of the ship as a defendant in the action in rem as a means of defending their jurisdiction or the jurisdiction of the High Court of Admiralty. That model was then exported to the US prior to independence, but in England, with the passing of the Judicature Acts in 1873, 1875, effectively ended the power struggle and the personification theory fell into decline. That's how we get to the so-called procedural theory, which was affirmed by the UK House of Lords in the Indian Grace No. 2 in 1998. The leading reasons by Lord Stein, in that case, likened personification to an old scaffolding that was used to erect a building that had to be discarded, since it was no longer necessary with the passing of the Judicature Act and the reconciliation that brought of Admiralty and common law courts. So while the procedural theory is more realistic than the personification theory, it has several important shortcomings, two of which Lord Stein himself identified but left for another day. First, it doesn't explain why maritime liens may be enforced against a bona fide purchaser. And secondly, it is not entirely consistent with the fact that certain maritime liens accrue independently of personal liability of the ship owner. In addition, the procedural theory does not explain why the action in rem continues and is limited to the res unless and until the owner liable in personam chooses to appear. Now, the debate between procedural and personification theories is not limited to the US and UK courts. Decisions in Australia, New Zealand, and Singapore have cast doubt on the reasoning in the Indian Grace No. 2, so tending to support personification. But at the same time, personification isn't fully adopted, and other than the US, the only major country in terms of tonnage to have adopted that or personification theory is Liberia. So clearly an endorsement there for the US Supreme Court, and there's some historical reasons, I'm sure, too. In civil law, when I used to practice in Venezuela, it doesn't recognize any legal personality in ships. The action in rem does not exist, and the vessel is treated like any other property of the owner, albeit one that can ground jurisdiction. So, what do we make of this? On the legal personality explanations, there are at least two that I consider in this presentation. The fiction theory of legal personality in general, which is rooted in natural law, and the pragmatist view, which is based on the positivist school of law. Another possible theory of the legal personality of ships may be the joint venture theory, which is proposed by Professor Martin Davies. I don't address it here due to time constraints, but it's well worth a read if you're ever interested. So the fiction theory of corporate personality, as I said, is rooted in natural law. It's a philosophical theory that holds that human beings are the natural substratum of all rights, and that the corporate body is but a fiction, a thing of the intellect. So the procedural theory of Ships' personality can easily be placed in this camp, since its ultimate conclusion is that by removing the fiction of Ships' personality, the individual owner can be found, flushed out, and punished, in commercial terms, held liable for the loss. The Indian Grace, number 2, itself adopts the fiction theory, and Lord Stein's reasons relied in some measure on the great natural law scholar Lon Fuller. Fuller's view is set out in his work Legal Fictions, is that personification, like the business corporation's fiction, may be classified as an abbreviatory fiction. That's a convenient shorthand whose purpose is to avoid an inconvenient circumlocution, and which should be eliminated once its utility is spent in order to uphold the internal morality of the law. Lord Stein, in his reasons, does recognize the instrumentality of the law, but by attempting to dispel the mystique of the personification theory in favor of a more realistic view of the nature of actions in rem, his decision continues to presuppose that human beings are the natural substratum of every right. So now, on the other hand, pragmatists proceed to define things in terms of their consequences, as opposed to their inherent nature. So, in his articles on corporate legal personality, John Dewey concluded that what makes a corporation a legal person is that the law treats it as such. It has the rights and duties assigned to it by the courts, which in the end determine the reach of corporate agency with respect to individuals, other corporate entities, and the state. Or, as Dewey himself stated, put roughly, person means what the law makes it mean. The question here is, do the facts support a conclusion that ships have legal personality? And the short answer has to be that it depends on the jurisdiction, since clearly there is a difference between the treatment of ships in the US and English Admiralty law. Nevertheless, it seems quite clear that at a minimum in both the US and the UK, maritime lien holders may sue ships without necessarily attracting the liability or requiring appearance in court of its owner. Furthermore, personification appears to be implicitly recognized in Section 28.2 of the United Nations Convention on the Law of the Sea, which is a section referring to arrests, and it refers to liabilities assumed or incurred by the ship itself in the course or for the purpose of its voyage. So, accordingly, from a pragmatic perspective, it is empirically accurate to say ships are persons because they are involved in a sufficient number of legal relationships or consequences. However, that personality is fundamentally passive in that it allows a ship to be sued, but rarely, if ever, to be sued independently of any third party. The only instance I know of a ship suing or where that's done is in collision cases. It's sometimes done, but it's not always, not the norm necessarily. So Now to the main question, should ships have legal personality? Is personification spent? The principal purpose of admiralty law, according to Robert Fisher at least, and I would agree, is to provide an effective debt collection system focused upon the proceeds of the ship. It doesn't appear to me that a debt collection system requires ships to have the capacity to sue. However, by giving ships the capacity to be sued, the law makes it considerably easier to prosecute claims incurred in the course of dealing with the ship, because it does a number of things. It provides claimants with a specific asset of value against which to direct their claim. B, it also provides them an additional forum in which to prosecute the claim, since arrest can ground jurisdiction. And C, it avoids the need to identify the owner in a number of cases. And in the complex and often secretive world of ship owning, with its plethora of shell companies, charters, subcharters, technical managers, commercial managers, etc., personification saves the maritime lien holder the arduous task of identifying and locating the owner ultimately responsible. So in these conditions, it's only fair that maritime claimants are not put through the task of pinning in personam liability on the owner. In addition, it also lowers transaction costs, because it doesn't require those dealing with the ship, such as necessary suppliers, to perform a full investigation of the ownership holding structure. It dispenses with that requirement. It would make very little sense for somebody to try and figure all that out, the ownership structure, if the ship's in port for a couple of hours or a day and it's going to provide certain necessaries to the ship. And I would also add that it enhances the speedy resolution of disputes and promotes efficiency by giving non-maritime lien holders, that is, those people that don't have a maritime lien and not protected that way, it gives them a very strong incentive to bring their claims early and fast, before the ship is sold or transferred to a third party. Finally, for those claims that are protected with liens, personification prevents the frustration of valid claims that would otherwise be barred by making the ship responsible regardless of a subsequent change of ownership. So this is particularly important given the mobility of ships and the relative ease with which they can be sold or otherwise dealt with. It also is relevant because of the nature and the kinds of people that are protected by maritime liens, so more vulnerable people, like crew members, salvors, etc., are valuable also because of the value of the services they provide. However, if the ship is truly the limit of liability, then it may also expose creditors to over-leveraged ships. So that's a bit of a problem. In Canada, our courts tend to say that they follow the procedural theory, but I would say it's more of a relaxed personification theory. The theory is there, but it's not entirely dead. The Cape Apricot decision makes it clear that a claimant may only arrest the wrongdoing ship or a sister ship, but not more than one, and bail is set at the value of the arrested ship and not the value of the claim. So if personification is truly a procedural device, then why shouldn't a plaintiff arrest more than one ship and get bail for its entire claim? That's the question for the next discussion. I look forward to your questions. Thank you for your attention, and good day.